Yeah, that's entirely wrong. And here's why, step by step. Fredrickson is essentially trying to create a procedural loophole that doesn't exist. 1. CRCP Rule 4, Summons Timing. Rule 4 sets time limits for filing complaints and issuing summonses, usually to ensure timely prosecution. In this case, he received a valid summons at the time of the stop. The citation includes the statute CRS 18-9-111, see date, time, and location. This satisfies the purpose of Rule 4, to notify the defendant of charges in a timely fashion. Open quote. The required time frame argument fails because the citation was issued contemporaneously with the stop. He was not prejudiced by delay. Close quote. 2. CRCP Rule 7, Complaint Sufficiency. Rule 7 requires a plain, concise, and definite statement of essential facts. A summons citation in Colorado is treated as the charging instrument for petty offenses or misdemeanors. The citation includes the statute, the date, time/place, defendant identification, instructions to appear in court. That satisfies Rule 7. Courts routinely hold that a properly issued citation is a valid complaint for purposes of Rule 7. Elements of the offense are alleged. Fredrickson claims the complaint doesn't explain how the conduct was unlawful. Look at the statute. CRS 18-9-111 requires 1. Intent to harass, annoy, or alarm. 2. One qualifying act. The citation references the statute directly, which automatically incorporates the statutory elements. At trial or in pretrial motions, the prosecution doesn't have to spell out every fact in the citation. That's what discovery and evidence are for. Open quote. Courts consistently reject the argument that a citation must restate the statute in plain English for the defendant. It doesn't. Close quote. Lack of signature timing is not fatal. Fredrickson argues a properly signed and timely instrument is fatal. But the police officer signed the citation was delivered to him at the stop, the judge confirmed receipt in court. Courts hold that actual delivery of a signed citation plus notice satisfies procedural requirements. There is no technical defect here that invalidates prosecution. NAR 5. Key point. He's trying to bootstrap procedural hyper-technicalities. This is a common sovereign citizen vexatious litigant tactic, claiming rules about signature, timing, or complaint form, ignoring actual notice and admissions. Courts do not entertain these arguments if the defendant knows the charge, there is evidence of conduct, a citation was properly issued and signed. Bottom line, Fredrickson's claim that the lack of properly signed and timely charging instrument is fatal is flatly wrong. Argument, reality. No valid charging document. He received a signed, statute-citing citation at the stop and in court. Citation doesn't allege elements. Citation references CRS 18-9-111, which contains all statutory elements. Timing under Rule 4, citation issued contemporaneously, no prejudice to defendant. Lack of complaint summons. Summons citation is a valid charging instrument in Colorado. Outcome, any motion based on this theory will be summarily denied. Repeating it could be counted as frivolous or abusive litigation. If you want, I can draft a concise, judge-ready point-by-point memo showing why his CRCP 4 and 7 arguments fail completely, citing both the statute and his own acknowledgments. This would be airtight.